pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, individual, liberty, and justice for all. Welcome to the October meeting of the Philipstown Planning Board. Ann, would you take the roll?
Sure. Andy Moranti.
Here.
Tim Connor. Here. David Hardy.
Here.
Mary Ellen Finger.
Here.
Joseph Giginta. And Neil Zuckerman.
Here.
We have minutes to approve, July 22nd, 2014. Are there any comments, additions, corrections, deletions? Hearing none. I'll entertain a motion to approve.
I'll make the motion.
Second? All in favor? Aye. Thank you. We rearranged the agenda a little bit to try and do a little housekeeping, get the quickies out of the way, so then we get to the heavy-duty stuff. So there's a couple of requests for withdrawal of applications, return of escrow. And the first one is RDR Equities, LLC. It was a site plan application on Route 9 Garrison. A letter dated August 8th regarding withdrawal, application, and return of escrow. Are there any comments on that? Anybody here from RDR? Comment from the board? Do we have any indication, Ann, from the town that there's no outstanding bills? Okay, I'll entertain a motion to accept the withdrawal application and return of any remaining escrow.
I'll make the motion.
Second?
Second.
All in favor? Okay, one more just like it. Hudson Highlands Reserve, Conservation Subdivision, East Mountain Road North and Horton Road, Cold Spring. We got a letter asking for a withdrawal of the application and request for return of escrow funds. Any questions on that one? Concerns? Motion to accept the withdrawal of the application and return of escrow funds? Second?
Second.
All in favor?
Aye.
Now, one more. There was a little bit of discussion about the GEX request for extension because there's been a lapse in time that may have been attributed to a miscommunication between the attorney for them and me back 2 months ago, maybe not. But so although they're about 6 days actually beyond the point where they might have had to refile a new application, I decided to go ahead and request the move to grant them an extension. There's been health reasons. They've been held up by the County Board of Health. So, Adam, are you familiar with this one? Any problem with that?
I am. And again, I defer to you, but our records indicate that the last extension, and maybe this is incorrect, was granted back on April 10.
That's right. And
we granted a 90-day extension, which means that it would have expired back on July 10, 2014. And unless your records indicate otherwise, I don't see any further requests for an extension made subsequently.
Now, Ann, you and I talked about this. There was a bridge between July 10th and this month. Another member of the firm that represented him, I believe, talked to me about it. And it may have been close to the meeting time. Is that correct?
Mr. Hilbert,
Yeah. And
attorney, July 24th meeting, had asked for the extension.
and somehow or other, it didn't get put on the agenda then. So to have applied for it this time, he would need to have gotten in October 10th. Is that correct?
Yeah.
So I don't want to set a precedent here, but I don't want to break the over 6 days either. If it's either 6 days or it's 3 months and 6 days, I mean, what's your opinion on that?
Well, if there was a miscommunication and there was a request made in July that just hasn't been documented inadvertently, and it's our bad, so to speak, then we can then entertain that. That wasn't, we had April, but if there was a request made in July, we can entertain it. If we don't entertain it, obviously she would have to reapply.
Right.
So
I guess I'll assume responsibility for that, although it was some time ago, and I'm not sure that phone communication. So unless, is there anybody on the board who wants to comment on this? Mary Ellen?
I just remember that they were coming back every 3 months, and I thought that they did come back in January.
Okay.
I remember seeing,
Kim?
I remember seeing the lawyer.
Okay. Is there anyone want to make a motion granting the request for extension? So moved. Second? Second. All in favor? Aye. Aye. Thank you. Okay, let's get to the meat of the hearing. Public hearing, ESP, subdivision site plan application. Ann, would you read the public notice? Put it in the record, Joe Giacinti recuses himself?
Application dated June 5th, 2014, for approval of site plan to continue the use of the Kerr property as a building supply yard and sales establishment. The intention is to eliminate nonconformities that have accumulated since the site was originally approved. Also, application dated July 3rd, 2014, for approval of a merger of 3 lots and a 2-lot subdivision. Total acreage is 11.239 acres. The front 2 parcels lie within the HC zoning district, and the rear parcel is currently vacant and lies within the RR zoning district. The subdivision would create 2 lots. Lot 1, on which the commercial activity would continue, would comprise of 7.217 acres after the lots are merged. Lot 2 would comprise of 4.022 acres and would obtain access from Stephanie Lane, a private road. Property location is 3330 Route 9 in the town of Philipstown, tax map number 16.20-18, 20, and 21.
Glenn, are you here speaking to the applicant?
Yeah, Glenn Watson from Beatty and Watson, representing ESP and Bruce and Donna Care. I would have remembered, but Adam didn't. Again, Glenn and Watson from Beatty and Watson, representing ESP and Bruce and Donna Care. As the public notice mentioned, this property is located on the on Route 9. It's a quarter of a mile or so south of the intersection of Eustis Road. It's on the east side of Route 9. I should preface that this application, again, as the public notice state, this application is for approval of a site plan and approval of a 2-lot subdivision. And note, there's a third application that's pending before the town board, and that's for a zoning change, which we are fully cognizant that this board doesn't have the ability to approve this unless we have the zoning change. So there's been a fair amount of discussion, both with this board and the town board over the last couple of years. At any rate, the Cares own 3 pieces of property which were bought separately. The first piece they bought is the piece with the ESP building on it. It's about 1.5 acres or so. I'm not sure which came second and which came third, but they bought a second piece. Both these first 2 pieces that I'm describing have the frontage on Route 9, and they contain the ESP yard, building, and the ESP operation. A few years ago, they bought a third piece, and again, I'm not sure if it was the second or third, 7 acres, in the hopes of rectifying some of their coverage problems, which, as it happens, that wasn't really available to them. And it's not available to them now as under the current zoning law. And it's well known around town. There have been a number of complaints. They've been to court over the extent of their use. So I'm going to talk about the site plan. Well, I guess I'm going to talk about the subdivision first. The subdivision the first thing that will happen if this is approved is that the Cares will merge these three properties so they're under a single deed. At that point, again, if this is all approved and the zoning change goes through, this entire piece of property will be zoned for commercial property. And that in itself raises a concern that was again discussed at length. They would then subdivide this property along this red line, subdivide the back property along this red line, leaving a 4+ acre parcel to the northeast portion of the property and a 7+ acre, I think it's a 7+ acre parcel on which the enterprise is located. The 7 acres represents the minimum, with a very minuscule buffer for my errors, the minimum needed in order to satisfy the coverage requirements of the town. Now, if you look at the sheer numbers of it, you'll see that we have, if you look at visually, you can see it's about 50-50, which would indicate that the coverage is, there's plenty of room and they could actually extend further back into this property were they to come back and ask for a site plan approval. But when you get a little deeper into that language, you see that any of the wetland buffer along Clove Creek, the steeper slopes, all have to be subtracted before you make that calculation. So what this is I think it's the 60% coverage of what's available for development plus that land that's not available for development. So of this 7 acres, this salmon-colored portion, which is the operational area of the project, that will have 60% coverage. So that's the first safeguard that's built into this plan, in that with the site plan being built on this larger of the two lots, it will when the site plan is put into effect, they will have maximized the extent of any development. There was further, so what other safeguards can we put in? We have in our application to the town board, and we've discussed it with the planning board before, we have agreed that this area on what will be the commercial lot will be restricted from any kind of development with a conservation easement, which is really, that's perpetual. It can't be changed by a zoning change. It's virtually perpetual. The only thing that would be allowed would be if there was ever a need for a septic system replacement from the septic system that's already currently on the property. It would be allowed to be in this upper portion of the property, about 20 feet vertically above the Clove Creek and a couple of 100 feet away from it, outside the Clove Creek buffer, outside of the floodplain. The remainder of the property would also be subject to a conservation easement that would restrict it to developing one lot. So we would have a 2-lot subdivision, 1 building lot, and 1 commercial lot. The entire property would be zoned commercial. And the reason for that is that if we were to leave, say, this residential portion of the property in its current zone, which I think is 5 or 10 acres, I haven't got those straight yet. We wouldn't have a conforming lot. We wouldn't be able you wouldn't be able to approve it without at least variances. So that poses a problem for the neighbor. So what we've proposed here is that there would be an additional zoning setback. Instead of the 15 feet that the commercial zone requires, it would, maybe it's 25 feet, it would be 50 feet, or at least double, and maybe a little more than double, where there would be no building permitted. So what would happen back here is that there would be 1 residential structure, again, conservation easement, and the zoning law would prevent any further development. This would not be subdividable. It would be limited to a single-family dwelling. It would be kept well on up on the property, out of the septic area. I'm sorry, out of the flood zone, out of the wetlands buffer and certainly out of the creek. So that's what the two-lot subdivision will do. Those are some of the restrictions that we're volunteering as part of the negotiation to get this zoning change. The reason for the zoning change is, again, so this lot can become legal, and so this lot can be created under the commercial zone, which is much less, it doesn't require as much area. The site plan, as I mentioned before, has been the subject of much discussion among the town officials and town courts and the neighbors and everything. The site plan we're proposing is doing several things. First of all, it's designed to bring this property totally into conformity. There are some encroachments on neighboring properties to the north. Those are specified to be removed. The adjacent property was zoned residential, I believe, and the buffer requirement that is in the zoning law would be, that buffer would be installed to provide visual protection to the people to the north. There is a new building that would be built along the frontage, actually quite close to the road. It would be a storage building. It will provide some visual protection for passers-by. It's in and of itself, it would provide screening from the yard, which you see from the road as you pass by. It's very evident. There's a fence that's going to delineate the extent of the proposed, of the allowable used area. Internally, it would function much the same as it has in the past, except that this new building is intended to store much of the materials that are stored outside, particularly expensive valves and things that weather and lose their value by being stored outside. The little cottage that is currently a rental unit will also be storage. We've left the internal workings. There's a note on this that makes the internal workings such that they would have some freedom to change their stockpiles and move it around. They wouldn't have to fence it and stay in this particular area. If they found that this route would be better, if they pushed these two together and made it a little wider, they would be able to do that. So within the yard, they'll have some freedom in terms of where the storage will be. They'll have screening along the south, the natural screening along the east, new screening along the north. All the violations would be encroached. The sign will be removed, will be moved to a legal location, and all of that in sum will bring the project together. As far as drainage is concerned, there's an on-site drainage system that functions very well. For those of you that don't know, the drainage, there's a lot of sand here. That's why Quarry Pond is as deep as it is, because they dug that much sand out of it. So there are leaching basins in here. Basically, there are catch basins that are empty in the bottom. The water goes into the catch basin and goes into the ground. Septic system is functioning fine, same situation. It's good sandy soil. Back here, everything we can see indicates that there's good sandy soil and suitable for septic systems. So we don't expect there'll be any drainage problems as a result of this. We don't anticipate the need for a new septic system, except for the eventual failure of those systems. They all fail eventually, but as in the immediate future, that will that's not anticipated at all. With that, I think I've exhausted my story.
Okay. Comments from Ron?
Yes, as you indicate, it's all predicated on successful petitioning of the town board. Where does that process stand?
I met with the town board about a month ago, early September, I think it was. I know it was in September, but over the period of time, mostly because of the changes in what I discussed about the restrictions on the back, I think I think that the balance of the sentiment of the board now is towards approving it. There was one member of the board that was particularly vocal against it. There was one member of the board that was particularly vocal for it. I'd say there were two that were for it. This is my personal assessment from my discussion. You may have read it. There was a report in the paper about that particular meeting, but most of that report happened after I had left the meeting. I thought the discussion of the project was over. But
Have they started down that process?
well, they have it in front of them. It has not been introduced. I don't think I think they're not going, they haven't like presented it as, introducing a new bill, which is a zoning change, right? But and I believe that they want to see where we go with you.
They're waiting for the planning board to go through the seeker process and this whole
Right.
subdivision
Well,
review.
you'll have to finish the secret process and, before they can act anyway, so all this is interrelated.
There's a comment, there's a paragraph from the July 22nd meeting from Steve Gaba, talking about how this is an unusual situation. He said the town board is literally, Adam, please correct me if I misinterpret Steve, that they're waiting for a response from us, possibly granting conditional approval from this board, and then the town board granting the zoning change, which would make the whole thing moot. It would just automatically go through. Is that correct, or am I misreading him? He says, granting a conditional approval, which is very unusual, is subject to town board approving the zoning change.
Right. In other words, all we can grant would be conditional, dependent on the town board approving zoning change.
Once the zoning change was approved by the town board, then this would automatically go through. They would get approval?
Well, whatever other conditions were there.
Yeah, I mean, we could set whatever conditions we deem to be appropriate, but all we can grant at best would be a conditional approval. Obviously, if the town board gives a thumbs down to the zoning change,
As you said, it all goes away.
it's moot. We couldn't approve something that's not approved by zoning.
Right.
But procedurally, the planning board can act in advance of that town board action, you're saying?
Correct, we can grant
Merely
conditional.
condition it, right.
Right.
approval, Yeah.
And according to the zoning, for them to make an amendment to the, changing it from RR to HC, it requires amendment. And it says here that the town board, upon application by the property owners or receipt of a resolution of the planning board, may amend the chapter, may amend. So it almost seems like it would require some sort of a resolution from the planning board.
Okay.
And going through
Granted.
this discovery process.
I wouldn't say that that's the case, because I think you already have the application from the owner. So I don't think it makes any difference.
There's been a petition to the board, but in the code, I believe it's still in the code where once the zoning change is introduced, they have a obligation, the town board has an obligation to refer the matter for your comment.
Right.
But I would suggest that if you do come to a positive conclusion, that perhaps you could include that positive recommendation in the resolution or with a parallel resolution and just be done with it, so it doesn't have to go back.
Okay, comments from the board? Neil?
So what happens if the zoning board does not approve this? What's the status? Let's say we approve what we can approve and the zoning board.
Oh, Neil.
Maybe we should get one more microphone. Let's say the zoning board submits what they submit, they're supportive across the board, your vocal opponent is voted down and... Town board, I'm sorry, oh, you're talking about the town board, sorry.
Town board.
Sorry, I thought you were talking about the ZBA, sorry. So the town board believes that, fine. But we recommend yes, they say no. What's the status of this property?
The status of the property remains illegal, and I don't think there's another solution to make it legal. And I've said this before, and I really don't want to say it as a threat.
Business goes forward.
The practical matter is that they have outgrown this site. They can make it work with the new building. So if they can't make it legal, they will be facing a continuous and ongoing charge of violating the zoning law, and they will have to move their operation.
Okay, anyone else? Dave? Kim?
So in rural residential zoning, you need 5 acres
Okay.
to be able to build a house. So that lot in the back is 7 acres?
No, the lot in back is 4.
The lot in the back is 4, no, I don't mean the new lot, the existing piece in the
The
back.
existing lot is,
Oh, that's 7, yeah.
Yeah.
Yeah, but that's a pre-existing non-conforming lot, even if it were 10
I'm
acres long.
the rural residential portion sorry. The rural residential portion that exists now, which is
Yeah.
separate from the rest, correct?
Yeah.
Yeah, is 7 acres?
It's, the parcel itself is 7.6 acres, and there's about 2/10 of an acre that's, this is part of the back lot, actually. It's its access. It's one of its access
right.
points. So and that's, I measured that today, that's about quarter of an acre. So it's about 7.4 acres back here.
Okay. What's 40,000 square feet in terms of an acre?
Well, it's 43,560 is an acre, so it's
Zoning acre.
8/10 of an acre. It's
So under highway commercial, you only need 1 acre
Right,
for a house.
right.
Okay.
And that would make this, if everything were perfect, that would make this theoretically subdividable. But one of the things that's offered in this zoning change is the conservation easement that would prevent it from being subdivided.
Okay.
Anything else from the board? Really? Ron, any comments?
well, the board previously made referrals. The county has responded. They've offered comments with their response letter that I think for the most part has been or will be addressed on the final plans. The applicant has some technical issues to resolve on both the site plan filing as well as the subdivision plat, but they can easily be resolved.
Okay, I guess we'll open it up to the audience. Use the microphone over here, please, and state your name.
Does Ann have to read,
What's that?
does she have to read the public comment statement?
We did in the beginning. Comments from the audience? Dave? State your name, please.
Yeah, Dave Morandi. I'm the vocal opponent to this from the town board, as referred to before, for a number of reasons. One, my main concern is, well, I have three actually concerns. One is the precedent this is setting to be running two applications concurrently, although I understand from the applicant's perspective, it's a very good thing. But if indeed the town board decides not to approve this, all of the work you're all doing, all of the time that's being spent on this is being wasted in my estimation, unless it can be used in the future somehow. So I think that, you know, that's a concern of mine, the precedent in this sense. I'm not sure where this stands. Richard hasn't kept the board in the loop as far as I'm concerned. I'm out of the loop, so I don't know what his decision is or why this hasn't come before us already. Mr. Watson did make a presentation before us, so I don't know what else is needed before he can actually bring this before us. I think it's having you do all this work to come to us is kind of putting the cart before the horse. So anyway, that's one concern. Second is, you know, I'm not sure the intent of the coverage law, but basically, you know, we have a law that it's set that so much coverage, 60% per for the site. And this basically, by restricting the rear properties and putting all of these restrictions on it, you're left basically with the same in the front that we have right now, in my estimation. So if there's a law and a reason behind it was to limit the amount of space covered, it seems like we're doing all this stuff, we're restricting the back lots, but you know, when all's said and done, we're left with pretty much the same as we had with the same amount of coverage, but now it's okay because we have the acreage in the back. So to me, that doesn't make, you know, logical sense. It makes sense, you know, if you want to look at it, and yes, they have the acreage, yes, once they have this, then they can do that, but, you know, the intent of the law seemed to be to limit the amount of coverage, and you're going to be left with that. The other thing, you know, Mr. Watson keeps saying this isn't a threat, but basically I take it as a threat that they're going to move. I mean, if that is or isn't the fact, whatever. It's been brought up several times. It's in our conscious. It's like, oh no, they're going to move. These are people, you know. So, you know, I take exception to that, you know, being presented every time. Also, the owners of this have been out of conformity for several years, or as far as I know, as long as the property's been owned. They've pretty much, you know, they've been cited, they've ignored all of this continually. I believe they just had a settlement and we had to go to court, which costs us money, costs them money, costs everyone money, to actually bring them into conformity. So it's all nice and well that now they're willing to conform because this is before you and because they want, you know, they want to have this a done deal. So of course they're going to say they're going to go into conformity. But my concern, and I'm sure some of the neighbors are, is that they haven't really, you know, cared what the law was up to this point. And that's not only their sign, which they added to just a few years ago, to the amount of, you know, of storage that they have on their property. So that's my saying. Thank you.
Thank you. Anyone else? Anybody else? Please.
Okay, my name is Joe Diebel. I live adjacent to the north, where Glenn's pointing, in that section there, of the back parcel. Stephanie Lane, 31 Stephanie Lane, Cold Spring. So I wrote something here, just kind of goes over the history of what I've seen occur at the Kerrs. The land on which Bruce Kerr runs his business, Expanded Supply Products, was once surrounded by tall, beautiful fir trees.
Excuse me, could you speak up a little bit? I have a tough time hearing. Speak up a little bit.
Yeah, I'll start over. The land on which Bruce Kerr runs his business, Expanded Supply Products, was once surrounded by tall, beautiful fir trees. He started taking those trees down in the mid-90s on the rear edge of his lot. This line of trees along the ridge was not Mr. Kerr's property, but belonged to his neighbor. Lawrence Merson was the owner of those trees, which stood on the residentially zoned back lot now in question. Merson would eventually sue Mr. Kerr after finding that Kerr had not only destroyed his trees by bulldozing them over the ledge, but had used the cleared area to store materials. Kerr was made to pay a settlement, but it didn't stop him from pushing more rubble over the ledge as years went by. My wife and I were witness to the bulldozing, and we had many discussions with Merson about the incident. Mr. Kerr then began taking down the 50-foot fir trees on the north edge of his lot, which were on the adjoining property of yet another neighbor. He had also been storing material on that property, which belongs to Joe Jacinta. Mr. Jacinta was forced to hire a lawyer and sue ESP. Mr. Kerr claimed adverse possession, and Jacinta was unable to reclaim all of his property. This dispute and the one with Merson were settled, but the trees were never replaced. In 2005, Bruce Kerr bought the 7.6-acre residentially zoned property located behind and to the east of his commercial property from the person who Merson sold to, Mr. Brea. Our property, which my wife Lisa and I have owned for 24 years, shares 755 feet of property line with this parcel. Mr. Kerr notified us that a portion of our driveway, which we had been maintaining and using for 15 years, traversed over the property line. This was something that both we and our title insurance company were unaware of. Mr. Kerr demanded that the driveway be moved within 18 days, or he would pursue legal action. I began the process of rectifying the situation immediately, working with our title insurance company. Needless to say, it was impossible to fix the problem in the amount of time Kerr was demanding, and it wasn't long before he sent letters threatening $1,200 per month for use of the driveway. My title insurance company began corresponding with Mr. Kerr to assure him that steps were being taken to solve the problem. Shortly thereafter, an abandoned car and a pile of concrete were placed in our driveway so that no one could pass. We paid Garrison Garage to move the blockade, only to find it replaced the next day. It was quickly found by the Cold Spring Police that Kerr was responsible. We did not press charges, and we paid to have the new driveway put in to appease Mr. Kerr. Ironically, the new plan presented to the board today uses our new driveway to access the proposed commercial lot instead of the original driveway, which still exists. In the proposal, the driveway access veers off our road and cuts through the buffer area, which is now a knoll full of very nice established shrubs and trees. Using our road as the access to the property instead of the road that is on his property destroys a buffer that is already in existence. It defeats the purpose of the buffer suggested on the plan for the back lot and invites misuse. So that's something I wrote. I just wanted to read something that was from a letter written to Andy Moranti from Barbara Barossa, who is a planner. She works for the Putnam County Department of Planning, Development, and Public Transportation. And this is dated July 9th, 2014. And she states a conservation easement should be placed on, this is referring to, the ESP plan. A conservation easement should be placed on the vacant lot to limit any potential incursion on this site in the future. Further, I would not recommend rezoning the vacant lot as it may encourage more intensive use of the site in the future. And I did have a couple of questions.
Can I interrupt for a second? Are we allowed to see whatever letter you just read
That
from
goes
someone
into the
else?
record, yes, it's official, part of the official record. We need copies of
Give you a
that.
copy of it.
Yeah,
Sure.
Yeah, you do.
Oh, we do have that power.
yeah, sure.
When would you like it?
Well,
Is that a trick question?
You got a deadline? No. Oh.
8 days. All right.
Oh, so yeah, I wrote down some questions as you were making your presentation. So a single deed, I was wondering, would that allow for the front part, like for instance, let's say the back lot, which is separate right now, it has a few right-of-ways that might be different from the front lot access to right-of-ways. By merging the deeds, does that give the front lot, the commercial, current existing commercial lot, would the right-of-ways roll over into it? Would that give access of the front lot to take advantage of the right-of-ways that exist altogether?
I'm understanding, and I'm reading into this a little bit, so correct me if I'm wrong. You want to know if, by doing this, merging the lots, if they could use Stephanie Lane to get over here into the back of their commercial property?
Yeah, by merging the deeds, does the commercial property then have, I guess, domain over the right-of-ways?
We're merging the deeds to form a single piece of property, but simultaneously, we're planning to subdivide it into 2 lots. So there would be no access to the commercial lot. There would be no right-of-way to get to Stephanie Lane. So I know that theoretically you couldn't use Stephanie Lane to get back up into the front, even if you merged it. There's a thing called overburdening, which I don't know an awful lot about, but I get the idea. This is all happening simultaneously. So for an instant, there would be one lot. Right then and there, that same closing, that same table, the two-lot subdivision would be made. This lot is all part of the Merson property. It would retain its right to use Stephanie Lane. This lot, although it is part of the Merson property and theoretically has a right to use it, it has no way to get there. So its access to that easement is blocked physically.
Physically?
Well, physically by another piece of property that intervenes. I don't mean physically like a fence.
I don't know if that answered my question, but, I mean, so the right-of-ways that this back lot has, if the deeds were merged, would not apply to the commercial part, even though everything's merged as commercial?
For the moment that it's merged as one big lot, yes. Following immediately, when the two-lot subdivision is made, it would not, because it doesn't have a way to get to it.
So when you make the two-lot subdivision, doesn't that happen at the same time? Like, you're rezoning it HC from residential. That's, I mean, what do you mean?
This is all going to have to happen at sit down at a table and sign a paper for the conservation easement, sign a paper for the merger, sign a deed for the merger, sign a deed for the conservation easement, sign deeds to put the lots 1 and 2 into separate ownerships. How they'll do that, I don't know exactly. Maybe one will go to ESP and one will go to them personally or something like that. But those things will all happen at the same closing.
Okay, well, I mean, my concern, I guess, should be obvious in that I would not like to see the right-of-ways that pertain to this back lot then become a right-of-way for the front lot.
To be perfectly frank, we would have no issue whatsoever with writing into the conservation easement and the deed for the lots, the conservation easement, that no right-of-way will be granted to connect this commercial lot to Stephanie Lane.
Which commercial lot?
The commercial lots, the whole thing, I'm sorry, the one that's going to be literally commercial, the ESP lot. So we write into the conservation easement is going to cover the entire back piece of property.
Right.
There'll be one set of restrictions on the part that's going to be attached to ESP's yard. There'll be a slightly different set of restrictions to the residential property that could be developed residentially. The main difference being that this one will not be able to be built on except for the septic system I mentioned early in my presentation. This one could have a house. Other than that, they're pretty much the same. But if the planning board so desires, in fact, I'll volunteer it, we can put into the conservation easement that there shall be no driveway or other connection between this, what I'm going to refer to as the commercially developed lot,
Right.
to Stephanie Lane. We'll put it in the deed. If that's a serious concern, and I appreciate that it could be, we'll put it in the conservation easement. And the conservation easement, incidentally, is we have to find some body to accept conservation easements. Can only be held by municipalities or by a place like Scenic Hudson or Open Space Institute. They enforce them. They go out. They have people that go out once a year and see if, I don't know, once a year, the ones I'm familiar with do it once a year.
Yeah.
Go out and monitor it and see if there are any violations, and if there are violations, they get the same sort of, the owner gets the same sort of letter as you got about that you described about your driveway. Maybe not as, maybe the language is a little softer, but.
Well, I just told it as it was, that's all.
So we can prevent that. The bottom line is we can prevent any connection by virtue of a restriction in the conservation easement.
Right. So why, I'm not clear on why making that parcel residential zoning and is so difficult, you know, where the 4-acre part, you've broken the 7.6 acre lot into, I think it's not residentially zoned, but the area that is sort of called residential, you call as a 4-acre portion.
Right.
Why is it difficult to make that residential and the other part HC?
Well, because the residential zone that's available is a 5-acre zone, all right? This line that's going to divide, let's call it the commercial lot to make life a little easier, from the residential lot. This line was created so that this coverage, basically that presently exists, is the maximum that you can have. I needed every square foot to make the math work.
You need that percentage of the back lot to make that legal up front.
Precisely. And what I think I started out by saying, if you look strictly at the percentage of what land versus the total, it's not that. There is land here that I can't count. I can't count the
Yeah,
wet
it's
land.
steep and wet.
I
so-
can't count that. And
Right.
so I discounted that. I took that out.
So you can't go any smaller there, is what
I
you're
can't go
saying,
any smaller. Right.
in order to make that conform.
You're right, I
the
can't do
front.
that. I can't do that.
Okay.
And that's really, frankly, that's really what prompted the recommendation to our client that they accepted, that we impose the same setback, a 50-foot setback, the same as, instead of this much lesser commercial setback. So there would be the normal,
Commercial's more than residential, the setback.
commercial has a smaller setback.
Oh, it has smaller.
But this zoning change would have a special provision that this particular parcel that's zoned commercial would have a larger setback as if it were residential.
Okay. Let's see. And I think I just wanted to point out, I think that lot actually was only allowed to have one house anyway because they didn't want to allow more than one house or 3 separate houses for this one drive. It was based on the size of the road because they didn't want over 3 houses using this road, I believe.
As a matter of fact, it's only allowed it's only one lot because it's not 10 acres. If
Yeah.
Ms. Connor said it's a 5-acre zone, and I'm sure it is. So we have 7 acres, so we can't divide it and get 2 5-acre lots out of 7 acres. So,
Right.
So as a practical matter, yeah, there's only one lot.
You can
back
only
there.
put one house on that
That's
big
correct.
lot anyway.
That's correct.
And, okay, so why was it determined to put the driveway where it is instead of using the existing one? I was just curious about that.
There's a knob of land right here that would have to be
Well-
plowed over,
Yes.
right? And the grading would be much more difficult and much more extensive than what we proposed.
Well, there's actually an existing driveway which is actually drawn on your previous plans, and it's the one I referred to in what I said earlier is I had been using a driveway, and it still exists for 15 years. The first 15 years I lived there, and it still exists. It's a well, I mean,
No,
I
I'm
put a lot of
familiar-
money into the driveway. It's
I'm
well.
familiar with it.
Okay. So it's there. So I'm wondering why that's not being used in this situation. Instead of using my newly constructed driveway, why does this driveway have to pass onto my property?
When we laid this out, we tried to do it to minimize the amount of grading and minimize the amount of disturbance. If we came over here, we would have to cut through a knob of land right through here. That would be quite a bit more disturbance.
There's nothing you have to cut through, and you're already cutting through it anyway, though, if there's anything to cut through. But there's really
It
nothing to
was
cut
more
through.
grading up there, if I recall correctly.
You're going to have more to cut through if you come through my place, though, than you are here. Because my driveway is below the grade of the old driveway, and you're going to have to cut through my buffer of well-established trees and open up my lot to this back lot, which defeats the purpose of this buffer that is supposedly being created here. And it's an easier, more direct route using the existing driveway. It doesn't make sense. You can't tell me you're cutting through anything here. I know the land better than anyone. I've lived there for 25 years.
Mr. Divo, can I ask you, I'm a little confused on just the locations and the drives. Where exactly, which house is yours on that back of that print?
The plane with the
Because
total.
I'm trying to follow this discussion.
This is our house,
Your house is back
and
there.
this is the old driveway.
And
Right
the old driveway, and where's the driveway that you,
Now, this is the
repaired or
one that
whatever.
we use now.
that's your driveway, or is that Stephanie Lane?
This is Stephanie Lane. It's Stephanie Lane, it's a private road, and this property has a right-of-way through it, but we thought the original driveway was their right-of-way to that property, but it was on their property. Bruce made us move it, and so there is still this existing road here.
No, we can take a look at that. I mean, we're not wedded to that if using that. It seems to me a little silly to have two parallel driveways, but if you'd prefer that, we can do that.
Well, what it does is it makes it more private for each property. It doesn't open me up to them, I'm not opened up, neither
open to
neighbor
that.
is opened up. There's actually a nicely established row of trees and bushes between the two, so it makes good sense. And plus it exists there.
We have no
I've put-
objection.
Pardon?
We have no objection. We'll do that.
Well, I appreciate that.
How many other residences are back off of Stephanie Lane?
I believe there's one residence here, and this residence, and that's it, right? I
two.
don't think there's another one. Is there?
And it does bring up a question. I'm not certain whether or not there is a right-of-way for the situation anyway, which, I mean, you would
No,
need a...
I'm certain there's a right-of-way. I'm certain there's a
You've looked
right-of-way
it
on
over
your
very
property
closely.
that benefits the Merson property. I'm certain.
And where, can you show me where you believe the right-of-way is for
In the
his
deeds.
property? Well, I have the deeds,
Well,
if you could point it out on the map.
oh, the right-of-way is a 20-foot wide strip that comes all the way back here, and it goes all the way over to here, and actually, your outbuilding is built on the right-of-way, is built within the right-of-way.
I don't understand, well, whatever.
Is that a problem, having something built on a right-of-way? If in fact it is a right-of-way?
It could be, sure.
Yeah. I mean, I went through
I'm
the,
just curious what it's a right-of-way to.
Excuse me, ma'am. We need to get your comments on the record. It's okay.
The right-of-way burdens your property, It's part of your property. This area from this line out to Route 9 is burdened by a right-of-way. The right-of-way benefits this property.
okay. All right, thank you.
Okay. Make sure the clerk gets a copy of those papers you have.
Should I drop it off at Town Hall?
And so-
Yeah, well. State your name, please.
Lisa Debo, I live on Stephanie Lane. In light of the many incidents over the years between Mr. Kerr and his neighbors, I take any appearance of good faith by the applicant with extreme skepticism. I hope the board will view this application with due caution as well. I am afraid the abutting neighbors of both ESP properties will pay a price for approving this application. In our case, there is the proposed destruction of the established buffer and the damage to our road, which would be incurred by the new intersection needed to veer off towards the proposed home. Complicated changes need to join the roads. It is a steep area, and drainage is already an issue. All this is completely unnecessary if the plan simply uses an existing road that is on Mr. Kerr's property, which we've kind of discussed. Please understand that I have no objection to a residence on this property. If this was an applicant who showed good faith, the details about the driveway and buffer would be my only concerns. Past performance by Mr. Kerr infers another potential price. I believe that he intends to use the plan to build a residence on Stephanie Lane as a ruse to give his business road access to store materials on the new property. There is no other road access to that property, proposed or otherwise. The approval of a residential property in need of access literally paves the way for ESP materials to overflow onto that property. Whether it is in violation of code to bring commercial industrial vehicles carrying industrial materials down Stephanie Lane matters not to him, as such codes and violations have not been a deterrent in the past. I am afraid that if there is a road there, he will use it. Will the town be diligent in enforcing violations? Once commercial zoning is given, won't enforcement be more difficult? What will the penalties be? I am sure the protection of the citizens of Philipstown's property and quality of life weigh heavily on your deliberations and decisions. In light of historical events, I hope there would be extra pause and weight given to that protection by this board. Thank you very much.
Yeah, would you give us a copy of that letter also? Okay, to the clerk at your earliest opportunity. Any others speaking? Ma'am, state your name and address.
Lori Ann Merrigan, 16 Stephanie Lane, on the north side of Bruce's property now. Just looking at the map now, that the tree line, that encroachment, what guarantees, how long does he have before he has to remove everything? I'm in the position that Joey was in. It's close to the time frame. He just puts things there, does what he wants. How do we know, how can we be guaranteed that he's not going to just do what he's doing now? He's been taken to court. He's been told of these violations. Like everybody says, just because he's got this extra acreage, what makes him not going to put more things on the property now? So that's my issue with that. I'd spoken to Glenn. He said that there's going to be a tree line there to block everything.
I did.
How long before that gets started, or when does that get started? Is there a deadline for it? How long is this project going to happen?
What is it? Is it a year or 2 years that that it has to be complete? Once the building permit is issued? I'm not sure.
Once it's started, I believe it's 2, is it not?
Well, does he just
No, it's a
ask
year.
for continuation of his building
A year?
permit?
You have to, if this is approved, and if it's all, you have a year to fulfill the conditions of the approval, then you have a period of time to do the work. You can't, a building permit may not be issued until all the conditions are met. That doesn't mean that the planting is put in. The planting can't be put in until all the conditions are met.
Right, of course. But in the meantime, I guess, okay, I'm waiting on that. So that's another year, 2, 3 years. So now are we into that, what's the squatter's rights, so to speak? What's the time frame for that? Do I lose my corner piece where that, the tree line is, which I'm assuming may be those trees that were knocked down? Okay, Jaginta's property is the first 50 feet or whatever along Bruce's north side. And then that tan area that's coming next, right there, that's all his materials on what I understand is my property.
Yeah, he does have an encroachment, so I said at the beginning of my presentation, yeah.
All right, so how many years does it go where all of a sudden that's all his and he just got another however many?
It's not just a period of time. I mean, there is a 10-year thing that adverse possession is a 10-year statute.
Well, then I want him off just very soon because it's close.
But this isn't the forum for that.
Okay.
Okay, that's the forum for your attorney to give him notice.
All right.
I can tell you that this site plan has specified that will be removed. I
Okay.
can tell you that he's reporting to court every couple of months to report whatever progress he makes, and he's going to be reporting to court until he has a CO on this building. And if he doesn't make the deadlines, and it just happened that he didn't make a deadline, he paid another big fine.
But he's got the money to do it.
Well,
Anyway,
no.
okay. Yeah, that's the problem.
what
And
can I
then
tell
next
you?
thing you know, it's 10 years and whatever.
Well, but
Okay, well, back to the map then. Okay, now, the way I understood, if there's a third house put on Stephanie Lane, What has to be done to the entranceway of Stephanie Lane? I thought we were told that it has to be widened off of Route 9.
I can tell you what the rules say. The rules say that before a building permit may be issued to a lot that relies on a private road, it has to be brought up to the private road standards, which means an 8-inch thick run-a-bank gravel driveway, 14 feet wide, graded so water doesn't run across it. The building inspector is supposed to go out and make an inspection and deny the building permit unless the road is satisfactory. I can also tell you that that doesn't often get done. I don't know about Mr. Donahue. I haven't, but in the past, it just sort of didn't happen. But,
Okay.
but that's
Now-
that's the rule.
Who becomes responsible for the
Excuse me.
cost of that?
Can you hold for just a second for a change of,
I know where
Who
you're.
becomes responsible for the cost of that?
Well,
Him
the
or the
tip-
road, the people on the road?
At that point, in that inspection, if he wanted a building, or he or whomever, and I will tell you that they don't have any immediate plans to build this thing, as far
Right.
as I know. But if he wanted a building permit, he has the right to go in there and build it. And, you know, within the right-of-way, he has the right to make himself a path, all right? As far as the maintenance is concerned, typically, these old ones, there's no maintenance agreement.
There's a road maintenance agreement for Stephanie Lane.
There is.
Yes.
And who's parties to it?
Right now, it's between us and Diebold, and as soon as the third owner, if and when a house is built on the third lot located on Stephanie Lane.
ma'am?
If and when a house is built on the third lot located on Stephanie Lane and a certificate of occupancy is issued for the house, the owners of that parcel will be approached to contribute to the cost of maintenance so that the cost will become as follows. Merrigan 33%, Diebold 33%, and the third lot owner 33%.
But there is
Well, I-
no legal compulsion there.
Let
is
me,
there?
This is filed with-
You can't make him sign that probably, but
That's right.
in the past, the planning board has, and I'm sure they'll do it again, the planning board has looked to owners to to people wanting approvals to get a maintenance agreement established. I wouldn't be surprised if they imposed a similar thing which required him to sign on to that maintenance
Right.
agreement as a property owner until, as a condition of the approval. They've done it many times in the past.
Okay.
So you have to lobby the planning board.
I have a copy you can have right now. You do? Of this? Sure. I think that was it. It's just, no, the biggest problem is that he just does what he wants to do when he wants to do it. And everybody's really afraid. I mean, this poor guy had a car parked in his driveway. What if there was a fire at his house? How were they going to get there? This car was literally dumped there. And now they want to use his driveway. That's my problem with this whole, I don't have a problem. It's really not going to affect us from what we can see. You know, they're going to see maybe a house or whatever. Right now, I'm looking at Bruce's buildings. I'm hearing his backhoes. I see his trucks being loaded. 7 o'clock in the morning, I hear trucks dumping pipe. I get it. I bought a piece of property next to a commercial piece of property. I get that. It's just, he just does. You know, the encroachment is a perfect example. He just does. And I just wish there could be some sort of guarantee or a deadline that he gets the stuff done within a certain period of time. And what does happen except for, oh, here, you're not in compliance of what you're supposed to do on your lot. Okay, you go to court, you pay a fine. Or he just procrastinates for another 10, 20 years, like he has done in the past. Or there's repercussions to the property owners next door for opening their mouths. That's my only issue with this. That's that. I hope you at least consider that when approving all this. Thank you.
Anyone else? Andy, state your name, please. You know the routine.
My name's Andy Schmar. My wife and I own the property on the southeast portion, not directly abutting because Clove Creek cuts across between the two properties. I'm not going to express or further the comments about the other neighbors and their concerns. I think you all heard them and will take them for what they're worth. My question is regarding conservation easements. During my day job, I've become familiar with this document. And so there are two things that I've learned over the last 10 years with regards to conservation easements. Number one, you need to make sure that the easement is ironclad. And easements have changed even in the last 10 years, so that my organization's conservation easement averaged probably 25 pages in terms of rights restrictions, terms that are conditioned for both the grantor and the grantee. And so I guess my question to the planning board's attorney is, do you or Steve Gaba have the expertise in conservation easements to the level that's needed these days for the very reasons that are cited, the concerns that are cited, that a deep-pocketed landowner who chooses to ignore zoning, in this case or any other, would just as easily ignore a conservation easement or find a means of violating that easement, or find a means of perhaps staying within the easement but not adhering to what the objective was originally. So my question is more of a technical one. Your firm's experience with conservation easements.
Well, I'll run it by Steve, but to the extent that as a condition of approval, the property will be burdened by an easement, a conservation easement, those easements are there to be enforced.
Yeah.
So that's going to be, if the planning board chooses to approve, and if, of course, there is a zoning change to allow this to go forward, the language will be in there in terms of the approval.
I guess my comment to the board is that make sure you have adequate and complete and expert counsel in the development of that conservation easement. I'm not saying that you all aren't, just make sure that the attorneys that draft that conservation easement, and I'll be happy to provide you a lot of names of very qualified attorneys, if they don't feel that they've had the experience in developing state-of-the-art 2014, 2015 conservation easement, be able to refer you to or refer them to those councils that have a lot of experience drafting easements right now. So that's my number one comment, is make sure it is the best document that you can to avoid problems in the future, unexpected problems that were never intended by this board or by maybe even the grantor, because this property eventually will change hands, and then a new owner may find a wedge to drive it through. The second point that I make, again, learned from experience and learned from reading experiences across the United States, is that enforcement is critical to any conservation easement. That means at least annual monitoring. That means vigilance on the part of neighbors to ensure that the easement is being adhered to by the grantor or by the successive owners. And so it goes to the point about enforcement of the zoning and the difficulties that have occurred with that regard. So I guess my question is to the attorney, in a normal conservation easement situation held by a nonprofit land trust or similar organization, if there is a violation, there's an escalating set of procedures that are undertaken to remediate or remedy that situation, first being a letter, but eventually you may have to litigate, you go to court, and I presume that's a civil action. Am I correct in that regard?
I think so, yes.
Would this be, if the town held, as Glenn said, a conservation easement, just as it holds the zoning for all intents and purposes, is that a civil action, or is that a different type of action that they take when they go to court with an owner who's violating zoning, let's say? And would it be similar, or would it be identical if the town went to court with regards to a conservation easement violation to them going to court concerning a zoning violation? I don't know the answer to that. It's sort of a curiosity of sorts, because I'm not familiar with municipalities that hold easements and how they enforce them. But I guess my question leads to, is there a different level of enforcement action that a municipality will take, or is it similar in every case?
Well, I mean, the municipality can take whatever appropriate action, including an equitable remedy, which would be a request to the court to order them to take a specific action or stop performing a specific action, ultimately under the penalty of contempt. If they don't do that, they can be held in contempt, and the court can impose whatever fines they deem appropriate.
So it would essentially be similar action as a zoning violation. It's just a different legal document is protecting the property.
Well, the holder of the right,
Right.
that has the easement, if it's being violated, can bring an action against the violator and seek whatever remedies are appropriate to enforce it.
Okay.
And then the court can enforce it.
Okay. So in certain respects, there's no difference if there's an easement on this property or if the zoning is protecting the land or reducing, removing or reducing the types of uses or subdivision or whatnot. The action would be similar. But in this case, if it is zoned commercial, you've got to have some other remedy to ensure that no further commercial activities occur on that property. But in the end, the enforcement would be executed in a similar manner.
Well, I mean,
if you needed to.
If I understand your question, you could theoretically have a zoning violation, which can be brought if they're using the property not in compliance with zoning.
Right.
You can bring an action to enforce that. If the issue is, okay, there's a violation of the terms of the conservation easement, the holder of the easement can go to court and seek equitable remedies.
Great. Well, that's what I'm asking as a neighbor, as somebody that might be impacted if suddenly a commercial activity spills down over it, that my expectation, and this is as much to the town board, because this board will be done when it approves this site plan, if it approves it, and the easement is executed, then it's incumbent upon the town and its resources, its code enforcement officer, to enforce that conservation easement just as that code enforcement officer is enforcing the zoning of the town. And that the town will then take the necessary remedies available at its disposal, litigation, whatever, to enforce this conservation easement as vigorously as it would the zoning. And that's not a question to you. I guess the expectation as a neighbor, that's what I would expect the town to do. Just as neighbors of properties that we hold conservation easements on absolutely expect us to take whatever steps are necessary to enforce those easements. I think that's what the neighbors would expect if if it were approved at these various levels here. Okay. Thank you.
Other comments from the audience? Ron, anything?
No, we've nothing.
I don't know, is the board ready to vote on this? I have a lot of questions on some of the things that were brought up by some of the public, and I've had these questions for a long time, and I don't know if anybody else on the board wants to express concerns about this before we even call for a vote. To close the public hearing, we can close the public hearing.
I'll make that motion.
Second.
All in favor?
Aye.
Aye. At this time, I don't know if I even want to entertain a vote. Unless somebody really wants to push it, and we see what we have as far as
As I spoke earlier in the meeting, there are various technical things that the applicant's representatives have to address on both the site plan and subdivision. And as you just note, there's significant issues still to be verified that came out of the public hearing process.
Well, let me get some of this on the record, because a lot of this came rushing back from, I've been familiar with this for over 10 years, maybe even longer. Because I remember when I was on a town board, I went to zoning board meetings, and I remember the applicant before the zoning board, violation after violation, and now as the neighbors are recounting. And one of the things that hit me, well, several things, is even with this melange of makeup here, we're still going to have a lot that, no matter what you say about 60% or anything else, it's still going to look like it looks today. I see stuff that's what I believe is well within the setback off of the center line of Route 9. Now,
There is
some-
no center line, well, there is a center line setback, but that setback was significantly reduced when the zoning law was passed.
To what is it now? It's not 50 feet?
I'll have to check. Setback from the road. State road. It says county road. 35 feet.
35 feet.
35 feet.
And yet, every time, often, not every time, when I go by this site, there's stuff like wooden skeds placed outside the fence. There's parking outside the fence within less than a stone's throw from the center line of Route 9. So, I mean, I don't see a change in the site that we're concerned with by adding this conservation easement behind it and all the other things that we've discussed tonight about Stephanie Lane and the house back there and so forth. I see, well, it's been out of conformity for years, and until their hand was forced, they want to expand the business, is how I see it. They want to put this large shed up front. I remember a businessman who lived in this town for many years, had a very successful business, and he said, I've had to move my business 3 times when it outgrew its site. And I have to echo one of the commenters here tonight that I kind of took that as a threat. 3 times I've heard that they don't want to move out of town. But if your business expands your site, you have to move out of town. I really think this is kind of a jury rig request that we're in front of us. So I don't know if we really want to, if the board members want to call for a vote on adopting or not. I don't know if we'd hold off on this.
Well, let me respond to you for just a second with regard to what is a threat and what is not a threat. That wasn't part of my presentation. It purposely wasn't part of my presentation. Mr. Zuckerman said, what's going to happen if we don't get it approved?
I said by the zoning, if the zoning change doesn't happen, is what I have.
Right, if the zoning change. But this whole thing, let me be clear.
You were for us for one thing, and there's a different thing going on, which is Dave's point, so I just want to be clear. My question was specifically about if
Right.
we said yes and the town board said no.
Right.
That was my question.
This
Which I
entire-
believe I asked the last time, too.
Everything that we talked about tonight has to happen if they're going to become, if they're going to have an opportunity to bring this thing into conformity. Everything has to happen. And your question was, what happens if it doesn't? If any one of those things failed, so whether it was regarding the zoning change or with the site plan approval or the subdivision, it didn't matter. The answer would have been the same. And they have told me, and they told me in conversations with other people, they expect this has a 10-year life. Right? If when they bring this into conformity, this has a 10-year life. And
I'm not sure I understand what you mean by that.
if their business continues to expand,
Oh.
they will be able to operate here for 10 years. They may decide not to grow it anymore, but if they can't bring it into conformity, they're not going to be in a position to come back here every 3 months and pay another $8,000 or $5,000 fine. So that was not part of my presentation. It was it was an honest response to a question. Andy, for years, people have been talking about enforcement on virtually every piece of property in this town. It has been a continuing problem. It has been improving slowly and gradually over the second year. What we're presenting to you is a site plan which will be a piece, which is basically the tool. It's sort of like the easement documentation that the conservation easement will have, the baseline documentation. If there's something out there and it's not approved on the site plan, he should be ticketed. And so what we're trying to do is create a situation where he can bring it into conformity. And I truly believe this is the only way.
One of the issues that struck me in the discussion presented by one of the residents was it seems to put the burden of enforcement and vigilance on the neighbors. And why is that so?
I didn't do that.
I'm not saying you. But the discussion of the neighbors from past experience seems to be that the burden is on the neighbors to keep this individual, keep this business on their own property, don't encumber other people's property, and so on and so forth. And if something gets out of the code or is in violation, it becomes incumbent on these people here who've expressed their concerns tonight.
Let me tell you about when I was a kid. You drive from Peekskill to Yorktown to Somers, where I lived. You could speed through Cortland, you could speed through Somers as a 16-year-old driving too fast and just out of control like 16-year-olds often are. But you didn't dare drive too fast in Yorktown. You didn't dare do it because they were vigilant as a code enforcement authority. Those police stopped you. And I will tell you, we drove up to the Yorktown line. It was right by the Amawalk Railroad Station on Route 202, and you slowed down. And I'll bet you there are places like that now still around here. And so human nature is, people are going to do with what they can get away with. I mean, not just Mr. Kerr.
I don't think that speaks too highly of the applicant, Glenn. I don't think that speaks too highly of the applicant, then.
No, but it's just everybody. It's everybody.
I disagree with you.
No,
I disagree.
It's an awful lot of people. Excuse me, it's not everybody. That's overstatement.
Well, anybody else on the board have comment?
So I'd just like to say that I actually agree with Mr. Morandi about the two-track process, because I think it sort of forces everybody's hand. If we approve it, then the town board's going to feel compelled to say, oh, it's okay with the planning board, so let's make this zoning change. If the town board approves it, it seems to me that the town board should be the first line here of deciding how we treat our zoning, which we carefully crafted. Do you know what the zoning was for this back piece before the new zoning came into effect? Was it residential?
It was probably R80. I'd have to check, because there were a couple of places along the line where it was pretty deep, the zoning. I don't know.
RE, you say?
I think it was probably R80,
R80,
2-acre residential,
2-acre
but I don't know for
residential.
certain.
Right. So the back piece has never been commercial since we've had zoning, probably, right?
Well, not as far as I know, but I'm not sure. I would think not.
It troubles me to start pushing that commercial buffer back.
It was already pushed back once because zoning was changed on the back of the property, but you were on the planning board at the time, and then on the town board at the time. The back end of the commercial piece was changed once before.
So that's my comment, is it seems awkward to be doing, two parallel processes. And I know that you came to us and
The
asked
other
us-
side of that coin, Kim, is that the town board will benefit from your comments and criticisms of the plan. I mean, so it's a chicken and egg situation, and we're really trying to run them as close to simultaneously as
understand.
possible.
Okay. Adam, where do we go from here?
Well, if you close the public hearing, if you're comfortable, doing that, then next month we would, have a seeker and site plan and subdivision resolutions. If you feel that you need more information, and there's been a fairly lengthy public hearing, it's going to be a lengthy record. One suggestion would be to, and it's up to you, to vote to keep the public hearing open.
Well, we just closed.
Well,
We can reopen
you
it.
can reopen it.
Well, I think we ought to, maybe we should do that. Reopen this. Mary Ellen?
If you feel that you need additional.
Well, I don't know. Ron's got issues that need to be addressed. These are technical issues.
Right, and I wouldn't be comfortable seeing the town or the planning board move forward without having
Right.
at least the documents revised and some understanding of how the comments raised by the public are going to be addressed. So it would be appropriate to have them back to one meeting, at least with some further answers before you consider action.
Mary Ellen?
I personally would like to see that document about the right-of-way. I'm uncomfortable with that being left there. I assume it's this dashed line on the drawing. And I'd like to, see the document that establishes that and consider having it extinguished so that there's not the opportunity for, more kind of the trespass that's been going on all this time.
I'd have to talk to my client about that. I would talk to.
Agreeing that you would be willing to follow the original road route that he refused to allow the neighbors to use that, therefore they had to build home. And that right away is going over their property.
I did agree that I would look at that. I didn't. I am not in a position to agree to give up a right that the person, a deeded right the person has. I am in a position to say, okay, we can work around with this existing driveway. It's an entirely differently weighted thing. We would be willing to waive any time constraints until the January meeting in order to wrap this up.
Okay.
We are actually not bound with it. There's a time constraint. Once the public hearing is closed, we'd be willing to agree to it. And moreover, it actually doesn't matter because you haven't closed seeker, so that outweighs all time constraints. So there's not a time constraint on you.
Okay, let's do that.
Well, I would make a motion, because you did indicate that the public hearing was closed.
Yeah.
I would make a motion to rescind the closure and reopen the public hearing if that's what the board wants to do.
Is that the,
I'm sure, I didn't catch why we have to reopen it. What's the status? Can you just explain that logic? What do we need to
additional
do?
outside
Well,
information?
they want additional, the board wants to consider additional information, wants additional answers, wants to respond to comments from the public. So, I mean, once
We won't
the,
respond to them.
well,
We want to see, we'd like
well,
to
there
take
would
in
be
more information.
theoretically
We need more
Not set the
information,
time
not
clock.
necessarily public
Oh, he's
comment,
just
but additional
verbally
information.
acknowledged that he'll.
Ron still has issues.
But does that require the public hearing to be open? I'm not,
Yes, if the public
Yeah.
hearing is closed, then there's a time clock.
We have to, yeah, where we're going.
fine, thank you.
And we'd be willing to waive that until the January meeting.
Okay, I'll entertain that motion.
Are we making a motion to waive it till
To-
January?
to
or are we making
rescind
a
it?
motion just to rescind the?
To rescind,
To rescind the
Yeah.
closure? Okay, I'll make that motion to rescind the closure.
second,
Second.
all in favor?
Aye.
Okay. Till January?
No. My offer to waive the time period of January
Oh,
was
okay.
predicated upon the public hearing remaining closed.
No, well,
I would like the public hearing continued next month. You have to set time certain or you have to republish.
okay. Well, let's publish it. We just voted to reopen, to rescind the closure, reopen.
So we'll continue at the next.
Continue to next meeting.
Thank you.
Now, we can go two ways on this. We got Horton Road LLC is a new application. I think we need to take a 5-minute break. In keeping with this meeting, we're going to move the agenda around again. We're going to continue with Old Stone Road site plan application, submission of the revised EAF Part 2. Glenn?
We submitted a revised EAF. Radio ones. We submitted a revised EAF. There were several changes in it, primarily responding to comments that from Ron Gaynor that were issued after we made the initial application. So what we're here tonight to ask you to consider the suggested Part 2 of the EAF, consider adopting that. So Mr. Gaynor may have some comments for you on that. And we had also asked, there was a question with regard to whether you could issue a special use permit or whether we needed variances for construction on the 20% slope. Mr. Gaba sent me a copy of his memo in response to that, and I would hope you would have some discussion concerning that so we get a little direction from that.
Okay. Ron, is there anything you want to address on the?
Yeah, as the board recognizes, Part 2 EAF has recently been filed by the applicant, and as the board is well aware, the Part 2 document is actually the board's responsibility to prepare, and so it's something you should formally adopt. It's recognized that Part 1 of EAF is the applicant's filing. That's their impression of the potential environmental impacts. You seek to perform the Part 2 assessment. That's been provided to you. I've been through it and had discussions with the applicant. I don't know if you want to review it in detail, but I can highlight the issues to just recognize the issues that I flagged that this Part 2 now identifies as issues of concern that warrant further review. And what results from this is if you adopt this as is or with modifications, the items that you've flagged as potential adverse impacts, they'll then prepare a Part 3 elaboration to identify the issues that you've noted as a concern. And if I can just walk through it and just use the general headers, there's just a few questions that are raised. Item 1, impact on land is obviously impacted or identified as yes, given the significant slopes that are being disturbed. And I'll just highlight the ones that we've indicated to be indicated as yes as a potential impact. Question 4 is a question on impacted groundwater. We've again identified that as yes.
This is a question I came up looking this over today.
Yep.
When item 4, impact on groundwater, we assume that says yes, and yet it says the only ones that are checked are no or small impact may occur. That's still great. That still requires a yes.
Yes, it's still appropriate because it's within that threshold.
Okay.
We want to identify, we want to acknowledge that it's an impact, and then you try to qualify the significance of the impact. Because others are just no, there's no impact at all. For example, on flooding, there's no impact there, and there's no other the delineated questions responded to. Let's see, we've touched on groundwater. I jump ahead to question 9, impact on aesthetic resources has been flagged as yes. And that is, various significant issues relative to view shed. Impact from publicly accessible viewpoints, things of that sort. Those things are all identified within that aesthetic category. Question 10, go ahead.
Within that, where it says other impacts, it's marked as small or impact may occur, but there's nothing written there. Does that mean that's a
Yeah, I've
no?
discussed that with the applicant. I think we've highlighted the items of note. I believe that's just an error. I just spoke to Glenn about it, and he concurs. I think that just has to be removed, because there's no basis to check it. I mean, we've covered the major items that you see up above. Question 10, impact on historic, archaeological resources, again, is checked yes, given the location that it's at. And for the balance of the questions, I concur with the answer of no. So we've flagged 3 or 4 categories that warrant further discussion or elaboration that could be resolved. Some of them may be resolved with additional filings to illustrate view sheds and things, but they require further elaboration in the record.
You mentioned 13. 13 be yes as well.
Oh, yeah, okay, thank you. Yeah, item 13, impact on transportation was also checked yes. And the significant issue there is just access to the site. We had raised that before. The significant construction plan, I believe the structure proposed is in the vicinity of 6,000 square feet, so there will be some major construction on that private road, so thank you, Kim. Yeah, so 10 has been checked as yes as well.
Is there anything the board member wants to ask Ron on this?
As I say, if the board concurs, or if you want to revise it and then adopt it, the action you want to take tonight is to formally adopt
Right.
the Part 2 and direct the applicant to prepare Part 3 elaborations as appropriate.
Yeah. Any questions from the board on this? I'll move, ask for a motion to adopt the revised EAF Part 2.
So moved.
Second? All in favor?
Aye.
Aye. Okay.
Thank you.
The second item was the letter from, or the memo from Steve Gaba. And if I understand it correctly, he says if you have a finding that allowing the construction on the steeper slopes reduces other environmental impacts, you might go with a special use permit. But if you don't, then a variance might be required. If I want to know that that's what I understand, if I understand it correctly.
If I could speak to that, the issue is the area of disturbances on steep slopes. You have a specific provision in your code that addresses it, 175-36. I had actually raised it originally in my initial technical memorandum, and had since raised it with Steve so we could get to some finality on it. This is the outcome of those discussions we've had, and Steve acknowledges that that section of the code does permit the board to allow disturbances on slopes greater than 20%, provided that you issue a special permit and you specifically identify the conditions under which you would permit that disturbance. So I guess what all the board needs to do is affirm or endorse the attorney's assessment of how this disturbance on slopes greater than 20% is addressed.
Can I ask a question? As I was I thought I had a handle on this when I was reading about it. You can build on slopes in excess of 20% if you can show that
You have to present a finding that
building on less
disturbance...
than 20 might cause greater disturbance.
Exactly.
Okay.
And for that, and that's the basis under which that code provision, that you're allowed to permit such disturbances.
Right.
I mean, the goal of the ordinance is to minimize disturbance of steep
Right.
slopes. That's the whole point of that environmental regulation in your code. But they do give you that caveat, that
Okay.
upon the...
Is that the case here?
Yeah.
Well, I would submit that if we were to take this house and put it on the ridge line, whereas the only place we have land that's less steep than 20%, the impact would be much greater.
And that's the point of the ordinance.
And that's, and
Well, it says less land disturbance and less overall impact, so it's both disturbance and impact, or just impact that you were describing?
well, I think the disturbance, I mean, just kind of in round numbers, the disturbance for building this house here or here is going to be more or less the same. And we can, and certainly the erosion control plan will address there's a greater likelihood for erosion on a steep slope. There's no getting away from that, but good erosion control measures can take care of that. So I would.
Okay, so what is the action required for us to deal with
I
this?
just put on the record the board's agreement of the attorney's assessment that upon a finding that the proposal would be permitted to disturb slopes in excess of 20%
Okay.
on the basis that the board finds creates less disturbance than compliance with the code provision.
All right, do we need to make a motion to that effect? Or we just accept the attorney's?
Yeah, I mean, I would just make a motion that the proposed construction can be made by way of a special permit under the provisions of 175-36 B7.
Okay. Motion to that effect?
I move that we give a special permit according to
Mary Ellen?
175-36B7 to allow the disturbance on slopes greater than 20%.
Thank you.
based on
Second
mitigation plan.
to that?
Second.
All in favor?
Aye.
Aye, thank you.
We'll submit a letter application for that special permit for when we submit this next month. Thank you.
Okay, thank you. All right, I won't get caught speeding in Yorktown, right? Okay, get the heavyweight out, folks. Oh, boy. Horton Road LLC. Hudson Highlands Reserve Conservation Subdivision, East Mountain Road, North Horton Road, Route 9, Cold Spring, new application.
Members of the board and members of the public. My name is Ulysses Liceaga. I am here representing the group of people that are applying for a conservation subdivision. This is the same piece of land that we submitted an application back in January. We were advised to withdraw that application because since then the same group acquired a fourth piece of land. This is just to give you guys a little bit of background in case it's needed. It's the same piece of land that the Lyons family had applied, and I believe they had gotten a permit for a soil mine a couple of years ago. So back in January, we expressed our desire to get conservation subdivision, which would be the first one to be pursued in Philipstown. And what has changed since is that we acquired, like I mentioned, a fourth piece of land here, which gave us rights to develop around this pond. Before, the Lyons property only had rights to develop on one side of the pond, and it had deed restrictions. So we believe that by acquiring that piece of property, it made the whole project rounder and in a way less intrusive onto Horton Road. In the last presentation, a member of the public, a neighbor of Horton Road, expressed concern about traffic. So what we are proposing now is, and it was part of our initial proposal, was to have our main access through Route 9. And again, a little bit of background is we are proposing subdivision of 28 lots with an equestrian center with 25 horses, an indoor rink for horses, and it would be a mix of a riding academy and a horse farm, a breeding facility, and equitation lessons. We have engaged the services of a local engineer who you may know, Mr. Watson, and we have engaged the services of multiple consultants, environmental consultants. We have had meetings with the DEC, we have had meetings with the DEP. Again, just to reiterate the past application, our intent is to build homes that will be platinum certified, LEED certified, extremely environmentally efficient, and that's, well, that, in a nutshell, that's our application.
Ron, any comments?
Yeah, the board has a technical memorandum from my office just to outline the the view of the project and more specifically the applicable conservation regulations that apply. This is very similar to the original project that you saw 9 months ago. The major change is that they now bought another parcel that picks up the southern part of the lake. So the plan's modified slightly. It's allowed for a few more lots. The original proposal was for 25 lots. This is now up to 28 lots. The variety of environmental constraints mapping that's mandated by our ordinance has been filed with the application, and that's really a subject for some hard review by this board. So you can be assured the intent of the conservation subdivision is to identify property of significance that's worthy of protection for conservation. It could be steep slopes, it could be, the water courses, the ponds, the wetlands. It could be areas where there's significant view sheds either into or out of the property. Much of that data is now shown on the constraints mapping that they have provided, which is obligated by the code. So in my view, my memorandum is somewhat detailed, but I wanted to make sure you understood clearly the process. I think your goal at this point, having this information in hand, is to now see if you can schedule or consider scheduling a site visit so you can better get a hands-on view of these areas of significance that you may deem worthy of protection, because that's going to drive the basis for where you want to see the development within the tract. They've given you a proposed subdivision layout, but at this point, you really need to be more focused on identifying areas that are worthy of protection or worthy of making sure they're not disturbed. And that most typically comes through a bit of a sidewalk that you'll have to perform.
Well, as you and I spoke, before we actually can do a site visit, we need to have a few things staked out so we know what we're looking for. It's 155-acre parcel.
Yeah, some major bearings through the tract have to be provided so you know where you are on plan.
Right.
And they've got, as the applicant indicates, they've got main access coming up off Route 9, which I think the board would find very appropriate. They have connections to adjacent existing town roadways on both the north and south, East Mountain Road North and on Horton Road. I think I'm speaking for the board somewhat, but I think I understand your views typically, and you'd want to be able to understand where those roads come out on existing roadway systems. So maybe generally locating where that center line is with some stationing so you can know where you are on the property might be helpful. You also want to make sure in understanding those points of access that you're not creating areas that become major thoroughfares. And you really want to drive access out to Route 9 so that you don't burden the existing residents on those streets where interconnections will be made. You can do that. I mean, the applicants tried to respect it by making curvilinear roadways and minimizing the desirability of going out the side streets. You'd want to understand that, and you'll have further comments when you're out there. But
Where's the entrance on
it's just
There's two.
south of more concrete.
Right next to the Pemcourt billboard? Where the cut is now. Between Pemcourt, yeah, where the cut is.
That would be the new road, was it Raleigh name? I forget the name now.
And I believe that's
a
the
Sally.
same entrance that was being
Proposed for
pursued
the-
by the soil mine.
Right.
Right. Now, looking at the, I don't want to get too far into this, but looking at the this site plans today, it seems to me as though you might take a serious consideration of Horton Road and the way some of those, I don't know if you call them feeder roads, but the roads, especially the housing around the pond and the other houses on the other side of that road, I'm wondering if that's going to be a natural tendency to come down there and exit through Horton Road or go out that middle road, the new road you're going to create.
Well, we have thought about that, and we have discussed the possibility of having a controlled gate, not an attendant gate, that will close access to service vehicles like post or deliveries, any kind of delivery, and it would almost be like an emergency exit for emergency vehicles. So we're trying to encourage use of Route 9, which personally I think it makes much more sense to use than Horton Road. It has much more direct access, and we had a meeting with an official from the DOT regarding this, and he suggested, well, if we don't have to open up a new road onto Route 9, it would be desirable, but we really want to get this access onto the development because of the size of the vehicles that we will need for servicing the equestrian center. Trailers going in with horses are usually the size of tractor trailers, and transportation of feed and manure out of the site. So we really want to have that road being the main road. And the one on Horton Road and East Mountain Road North being almost emergency alternate routes.
Okay.
I don't know if the board ultimately support that layout or not. It's going to be your decision
Right.
once you start looking at site-specific issues. My immediate view of the access towards Horton Road, and there's 2 points of access that come to the property line, my view is that you only need one, and you'd probably make it the more curvilinear, the longer paths, just to prevent an easy shot through the to the project, and they could easily accommodate it, still satisfy their desired lot count. All those details will get worked out later, but it'll be those things that you want to look at when you're on site, because you want to respect impacts to the neighboring properties.
Particularly because it goes through wetlands and
Right.
it's in a floodplain.
So where is the equestrian center on this? Is it listed somewhere on all these drawings? I don't see it anywhere.
Well, right, it is this more significant building.
Here?
They had one set,
This
they
one.
had one set of colored prints.
What number house is it next to?
All right, it is right in front of lot 24 and 25.
You want to say that one more time?
Right in front of house 24 and 25.
Fine, thanks. All right, thank you. So Andy, do we have to approve that along with?
That's part of the application, I'm assuming.
Right. That's a long way to go, but you'll be looking into that as well.
Paddock, that's the
So
paddock, right?
That's not identified specifically as a separate buildable lot, but it's a proposed structure on the common lands. That'll something we'll resolve with the attorney's office to understand the specifics of that approval.
So in general, in reading some of the code, that a subdivision like this is allowed to have some sort of a clubhouse. Does that fall under that? And
Those are the questions we're going to
This
resolve
is
with the
down the
attorney's
road
office.
then.
Exactly.
We hope
So
that it's
the
not too far
equestrian
down the road,
center-
I'm sorry.
That's good.
So this would be a use that would be both for the people that live there and for other people. Is that right?
That's correct.
Okay. So then that's a discussion for later.
Right, and I'll make sure that gets in front of the attorney for consideration.
So what should we do now? You just try to schedule a site visit, contingent upon their marking things up so that we know what we're looking at. Get there.
What effort is involved in providing some access ways or paths along your intended?
Couple of days of staking the road. We've located over 3,000 trees, and they all have tags on them, so we'll just figure out how far off the trees and just pull off the trees. I'm not going to go
No, we don't need anything
Yeah,
accurate.
right.
We just need to know where we are on your maps. Right.
Yeah, that's easy. I mean, I can't do it by this Sunday, but I could do it by next Sunday in a pinch and would prefer the Sunday following that. Just to make sure it gets done.
So we're talking about the second week of November?
I prefer this Sunday.
Is it possible for us to have copies of all of these different easements which have development restrictions? I'm on the appendix of this package. It says, I don't know what page it is, but it's under encumbrances. D1.
We certainly, they're referred to in the deeds?
Well, yeah, it says easement rights contained, area to be restricted from development, see Lever, blah, blah, blah. Just like to know what those things are.
Okay.
You give a date?
Yeah, November 9th. Mary Ellen has a question.
Yeah, Mary Ellen?
What date did you suggest?
One question I wanted to have a clarification made with conservation easements. What I see here is a great deal of fragmentation of the ecosystems, the way it's developed in all the roadways. And I know the conservation subdivision was supposed to help preserve not only open space, but ecosystems. And I just want to get this confirmed that these lots are about 1.5 acres each. And is it true according to, I just want to have this confirmed, that 175-11D 2 with common sewage disposal services, you can have lots 1/2 acre in size to encourage cluster housing and prevent this kind of complete fragment, because it's
Again,
cutting all corridors up.
We have engaged the services of Betty and Watson to take a look at all the ordinances. And the ones that we found call for 1.2 acres. Where is it?
I think there's an easier answer to that. There's a sense that this market is not going to want 1/4 acre lots. But at the same time, we will be developing building envelopes within the lots, so that portions of each of these lots will be subject to the conservation easement. And if you read into the code, you read through the code, you'll see that the actual land does not have to be held by a conservation entity. The conservation area set aside for conservation can be part of the individual lots. So essentially, we're going to have a 1.5 acre lot and maybe a 1/2 acre of unrestricted building area. The rest of it will be restricted. We haven't gotten to drawing those lines.
And if I may,
175-20, the conservation subdivision code, is that what
It's in there, yeah, I can't tell you what line it's on, but.
if I may, just to make it more graphic, I could show you